So the question is whether weapons charges in California can be dropped. The short answer is yes. But first, to really understand why and how, you need to kind of break down the ways in which it might happen and think about why it would happen. First of all, if someone's charged with a crime, ideally, it should only be because a prosecutor who files the charges believes, based on the evidence that's been presented to them, that the case can be proven, that 12 people from the community serving as a jury would in fact find the defendant guilty based on the evidence that's been presented to the prosecutor, usually by the police. So in that circumstance, can the charges be dropped? And as I said, the short answer is yes. A prosecutor always has the power to dismiss a criminal complaint, a criminal filing against a defendant. That is the discretion and the authority of the prosecutor. And so if the prosecutor is presented with information subsequent to the filing of the charges, if they're presented with information that suggests to them that either the person is in fact innocent, or at the very least that the prosecutor will not be able to prove the person's guilt to 12 people from the community, then the prosecutor has an ethical duty to dismiss the charges at that point. A court can dismiss the charges under some limited circumstances. Though the court has most of the power, obviously, in the courtroom, the judge does not always have the power just to dismiss any charges just because they don't personally feel that the charges are well-founded. However, one circumstance in which the court can take this extraordinary step is in a preliminary hearing. In all felony prosecutions in California, a defendant is entitled to a procedure called a preliminary hearing. There are a few exceptions to that, but we don't need to discuss that here because for the vast overwhelming majority of prosecutions, the defendant gets what's called the preliminary hearing. And that's the first stage of a criminal prosecution in which the prosecutor must demonstrate to the court that they have enough evidence, not that they will in fact get a jury to agree that the person is guilty, but essentially enough evidence to convince the court that the prosecutor should be allowed to continue prosecuting the person. That's a much lower standard. If the prosecutor fails to present enough evidence at that preliminary hearing for the court to entertain a strong suspicion that the person is in fact guilty of the weapons possession, then the court has an obligation to discharge those particular charges. In other very limited, more rare and unusual circumstances, the court does have an extraordinary power under Penal Code Section 1385, in which the court can dismiss cases on its own discretion, or certain charges, I should say. But as I said, it's very limited. The court cannot just do that anytime it feels. There has to be some showing that the prosecution essentially is unjust, unwarranted, and should not continue at that point, in which case the court itself can dismiss the charges. Now, why would a court do that if there's sufficient evidence to at least entertain a strong suspicion? It wouldn't. In that circumstance, it would certainly be presented to the jury. And then obviously, the final way all cases can be, all charges can be dropped is by a jury verdict, which is not really the dropping of the charges because you've really actually tested the charges to their full conclusion, but it is a way to make it go away if the jury agrees that the defendant is not guilty.